To this now, the High Court in Pretoria has ordered that SARS must give amaBhungane and the Financial Mail copies of Zuma's tax records for the years between 2010 and 2018. Now, Sars Commissioner Edward Kieswetter says they're still deliberating on how to proceed after that ruling. He joins us now via Zoom. Mr. Kieswetter, thank you very much for your time this afternoon. So Judge Davis has in fact set aside the decision to deny a media house access to former President Jacob Zuma's tax records. But before we get to the orders and whether you're looking to appeal or not, can we just discuss the argument that you relied upon, which the judge found is not universal truth? You had contended that without the statutory guarantee of confidentiality, the expectation that taxpayers will be candid and accurate with SARS diminishes. But Judge Davis said no, there are many tax regimes in other jurisdictions with far less secrecy, but tax administration is not hampered. Do you still hold that view that administration would be hampered in this regard?
Mfundo, yes, thank you. We absolutely hold that view. But before we even get to our view, let's just stand back and look at the facts in law, the legal prescripts by which SARS operates. First of all, this issue has to do with whether or not taxpayer right to privacy is an absolute right or not. And the law is very clear that it is not an absolute right. But the law further defines to SARS within the Tax Administration Act under what conditions SARS may disclose the information. And as the Commissioner of SARS and our organization, I may not break the law unless one of those conditions apply. Secondly, our general body of laws, including the Constitution, makes provision under certain conditions for access to information. The Constitution, for example, defines in Section 32 under what conditions access to information may be allowed, but then the Promotion of Access to Information Act then sets out those conditions. And neither in the Tax Administration Act nor in the Promotion of Access for Information Act is taxpayer rights included as a mandatory override. And so that's our legal position. The rationale for taxpayer privacy is the point we make, that it is in line with an international best practice to achieve voluntary compliance. But let me also point out, no, ask the question, it's fine.
Yes, you speak of international best practice, but your opponents brought in some defense. They went on to argue against this, that it's not necessarily the case. Like I said, that we have several regimes, tax regimes in other jurisdictions that have not held on to this secrecy position, and it hasn't hampered tax administration. So that seems to have fallen off the wayside insofar as the judge is concerned, wouldn't you say? Because he wasn't that much persuaded.
Well, I'm not going to unpack the judgment specifically or the reasoning of the judge. Let me just say that South Africa is one of those countries that follows the best practice of taxpayer right to privacy, firstly. And there are many credible jurisdictions that follow that right. Secondly, the fact is our law dictates what we can do, not only international best practice. And so we are compelled to act in terms of the legal prescripts under which we administer the tax laws. And so that's why I said just pause on our argument and first start by understanding the law.
The law, yes.
And then of course, we overlay our arguments on the law.
And then if we had to go to the TAA itself, if we just look at perhaps Section 67, subsection 5, which speaks of SARS disclosing tax records to protect its integrity, as well as Section 70 on disclosing to state organs, as well as Section 71, which speaks to disclosing to police. I know that you used this, or you argued that this allows for certain instances where you can disclose. But as a media practitioner, we would say that we're not included in that part of the legislation where if we wanted access to certain records, perhaps if there was allegations of contravention of the law, we're not included in that respect, would you say?
Absolutely. So in order to remove discretion, from the Commissioner in as far as taxpayer confidentiality is concerned, the law is very clear under which instances, as you have referred to those sections, the Commissioner may disclose taxpayer. When it gets to SARS confidential information, the Commissioner has some discretion. When it gets to taxpayer information, there is no discretion. The Commissioner and the organization is compelled to obey the law. I think what's also important, Mfundo, and maybe very valuable for the listeners to understand, is this is not about defending the right of a single taxpayer. We administer our law without fear or favor, and we are no respecter of individuals in this regard. So this is the right of every taxpayer, including you and me. But let me just say, so that our listeners understand, those who may be on the side of supporting this judgment, let me just say, be careful what you wish for, because the implication of this judgment is that in future, any third party may request of SARS the information about any of our taxpayers, claiming that's in the interest of public interest. And once they have that information, they may use the information and further disseminate it to anyone they choose to. That's the effect of this judgment. And this is our concern. This is our concern. In as far as our next actions are concerned, we have a well-governed process. The judgment is being studied within our governance processes by a committee that is set aside for that. They will obviously also consult with the SARS legal counsel and then make a recommendation to the Commissioner in terms of what our next steps are.
But some may argue. Yes. You can continue, Mr. Kieswetter.
No, I'm just saying in the meantime, I thought it's useful to explain to those who are listening the implication of this judgment and the fact that our reading of the law does not give us any discretion to disseminate taxpayer information to anyone other than how it is defined in our Act.
No, fair enough. But if we have to go back to this argument that it could open floodgates for you and I, just ordinary citizens, and that they could just claim that it's in the public interest to get Mfundo's tax records. But that claim, one would assume, would have to be substantiated, and then we would have a final arbiter. You would have to put a claim that, yes, Mfundo's records are in the interest of the public. So wouldn't you say there's still that leeway or that guard against abusing this type of a judgment in that respect?
Mfundo, you've read the Acts, if I listened to you earlier on. And the one instance, if a taxpayer feels they need that, they can approach the High Court. The High Court, however, as you said in Section 69, they will make a ruling if, in their view, the information is central to a case that is before it. And the other areas is clearly when there is an investigation and the South African Police Service, the National Prosecuting Authority, or one of the other agencies of state are involved in an investigation and the information is relevant to that investigation. And then the point that you made is when a taxpayer defames SARS by disclosing unlawfully or incorrectly a position that SARS has taken, then SARS, in defense of its own, the taxpayer then gives up the right to confidentiality. But those are the only provisions, and the law is very clear what those Chapter 9 and other entities are to whom we may disclose information.
Perhaps to the one that most people are interested on now. Where to from here? I mean, you've been slapped with a cost order and you're supposed to actually surrender the documents in 10 days. Are you looking to appeal this judgment?
Well, whether or not we appeal that I will be guided by the committee that is, to whom that authority is delegated, and will act on their advice. So needless to say, that committee is studying the judgment. It's reviewing all of the evidence and the affidavits that we have submitted. It is consulting with our legal counsel, and we have 10 days within which we need to decide what we do and then act on it.
But judging from our conversation now, I would say you're leaning towards appealing. You still seem to hold these views. Then perhaps something more controversial that I could ask then. If you hold the view that, you know, the secrecy is sacrosanct, that you cannot, it is illegal, then some have been saying on social media that if that is the case, we know that this particular case emanates from the book by Jacques Paul. He seems to have gotten access to some of those records, or at least he was given information by perhaps somebody within SARS, we assume. Has that been somewhat of a concern for SARS in that respect?
You know, Mfundo, SARS has many concerns, including what we hear in newspapers, including what we listen to on social media, including what authors may or may not put in the book. But can you imagine if we accepted every disclosure or anything that is reported in a book as necessary evidentiary material on which we act? So I don't have any basis on which to accept any publication as a basis that informs the action of SARS. And if SARS in any event, in any matter, decides to respond to any information that is brought to its attention in the public domain, we would pursue such an investigation within the confines of confidentiality. We do not conduct investigations in the public arena.
No, Mr. Kieswetter, thank you very much for your time. It will be interesting to find out what you guys resolve to do with this one. Thank you very much for joining us. That's Sars Commissioner Edward Kieswetter talking to us on that case, which has in fact set aside their decision to deny a media house access to those tax records. It remains a very interesting case, and he has said, be warned, if you support it, it could open a floodgate. You and I could be next.